So a lot of people, now that we have a permanent $30 million exemption, should revisit their estate documents and make sure they're not going to lose out on that step up in basis. And so they need to meet with their estate attorney, review their documents, and make sure that they can capture that tax benefit. Yeah, so I wanted to tell you about the one big beautiful bill that the president just signed, how it relates to estate tax and estate tax planning. They literally call it the one big beautiful bill, so we'll call it OBA. That had a lot of different tax provisions in it, but one of them that's essential for estate tax purposes and estate planning is the amount that you can leave tax-free at death or pass during life tax-free. Most tax laws tend to have a shelf life of about 10 years due to procedures they use in the Senate. And so the Trump tax cut from 2017 had doubled the estate tax exemption. It used to be $5.5 million. With this inflation, it had gone to $7 million, and they doubled it, so it was almost $14 million this year. But if they didn't extend the Trump tax cut, that exemption would be cut in half January 1st, 2026. So it would go back down to 7. So there was a lot of concern that people needed to use the exemption before they lost half the exemption. Well, in the big beautiful bill, they made that exemption, the $14 million exemption, permanent. Permanent in quotes, because any Congress can change the law, but it no longer has an expiration date on it, which has been the case for decades. We've always had to go through these cycles of, oh my goodness, the law's going to change. What do we do? Now we've got a permanent tax law. And they actually raise it next year to $15 million. So for a married couple, that means they can pass $30 million estate tax free during life or at death. That has some essential effects on estate planning. Historically, people are always concerned more about the estate tax because the estate tax rates have always been higher than income tax, particularly capital gains rates. So a lot of people did their estate planning over the years with complicated estate planning documents that created trusts that were designed to avoid the estate tax. And we've done that for clients for years and years and years. Now that we know the exemption is $30 million, there's a huge percentage of people who never will have to worry about the estate tax. They're never going to have $30 million of assets. But there's another tax benefit that people forget about at death, and it's called a step-up in basis. And what that means is if you bought a share of stock in Home Depot for $20 a share, and it's trading at $50 a share, and you die, the government says we get to adjust the cost basis to the fair market value as of the date of your death, so your family can inherit that stock and sell it the next day and pay no capital gains tax. Well, unfortunately, you can't have both. You can't have estate tax savings and a step-up in basis. And lots of people who will never have an estate tax because their estate will never be more than $30 million have wills that sacrifice that step-up in basis rule. And so a lot of people, now that we have a permanent $30 million exemption, should revisit their estate documents and make sure they're not going to lose out on that step-up in basis. And so they need to meet with their estate attorney, review their documents, and make sure that they can capture that tax benefit. Of course, there are people out there who will have a $30 million estate, and they still need to think about the estate tax. Appreciation is really your enemy in the estate tax world. So if you had an estate that was exactly $30 million, there'd be no estate tax. But every dollar that your net worth goes up, that's subject to estate tax when the surviving spouse dies, and that's a 40% tax. So there are lots of people who still need to worry about estate tax, and the planning is relatively simple. If they have loads of money, they may want to use that $15 million exemption now and give that away in the form of gifted assets. But since that's a permanent law, maybe the real answer is just not to have the appreciation occur. So instead of, you have, $15 million of Home Depot stock, and it's at $20 a share. You bought it and it's now, $50 a share, yeah, you can get a step up in basis, but your family will pay 40% estate tax on every dollar of appreciation in that Home Depot stock. So maybe the answer is that you give away the appreciation in that stock going forward, so we don't pay estate tax on that. And there are various techniques to do that. The simplest is creating a trust and selling the Home Depot stock to the trust. Call it $15 million of Home Depot stock. You'll sell it and you'll get back a note receivable for $15 million. So you haven't made a gift. You've essentially just sold the stock to the trust. And the trust can be structured in a way that you don't pay any capital gains tax on it. From that point forward, the trust now owns the stock, and every time it goes up $1 in value, that's outside of your estate. You've essentially just frozen the value of your estate at $15 million because you have a note receivable for $15 million. You'll get some interest on that, but as the Home Depot stock appreciates, all the appreciation belongs to the trust, and the trust is not part of your taxable estate. So that's a vehicle that we use for a lot of clients who would otherwise have an estate worth more than 15, or a married couple that's worth more than 30, to remove the appreciation going forward from their estate. They'll give up that step up in basis, but at current tax rates, that's a lot less than the 40% estate tax. So there's two types of planning now. One is for folks who will never be over 15 or 30 million as a married couple, and those who will be over 15 or 30 million as a married couple. They're two diametrically opposed planning, and so it's a good time for folks to revisit their estate plan in light of the one big beautiful bill and figure out if that applies to them.